Hello and a very warm welcome to Waitman's webinar on how to have a without prejudice or protected conversation. My name is Mark Land and I'm a partner with our employment team, and today I'm going to be looking at the practicalities around having an off-the-record discussion with a view to resolving workplace issues and or discussing the termination of employment. I also want to just refer at the outset to some sources of guidance. As you will hear in a minute, there are two vehicles by which you can have an off-the-record conversation. One is the common law without prejudice principle, and the second is a statutory provision which came in July 2013, and this is under section 111A of the Employment Rights Act. And what I've done on this slide is to list some sources of guidance published by ACAS in support of the new statutory provisions. One is an 8-page code of practice, and that's a statutory code of practice which a tribunal would have to have regard to where relevant, and that really focuses on the confidentiality provisions leading up to a settlement agreement. The second is a more detailed 82-page practical guidance note which covers both confidential negotiations and drafting settlement agreements themselves, including model letters, a model settlement agreement, and explanatory notes. Those are all available via Google online. You can download them, and I would strongly recommend them to anybody who is going to be having some sort of confidential conversation. At the end of the seminar, you will be sent a copy of the slides, and so you will have all the information there which you can use. Now, in order to review the practicalities involved in having some off-the-record conversation with an employee, it is necessary first to remind ourselves of the legal framework which governs such conversations. Courts have long recognized that there is commercial merit in enabling employers and employees to have frank and honest discussions with a view to settling an issue, and without the risk of those discussions being cited by either party in subsequent legal proceedings. And the confidentiality of such discussions is enabled by one or both of two mechanisms. The first is the common law without prejudice principle, and the second, more recent one, which was introduced in July 2013, is a statutory provision under section 111A of the Employment Rights Act, which enables what are called protected conversations. Now, what I'm going to do is to have a look at both of these vehicles because there are certain limitations as to the extent to which you can have confidential conversations. And so we're going to start by looking at the without prejudice principle. Now, this is a common law principle that prevents verbal or written settlement discussions and agreements being disclosed in subsequent legal proceedings. It is, however, subject to three preconditions. First, there must be an existing dispute between the parties. Second, the discussions must take place in a genuine attempt to settle that dispute. And finally, none of the limited exceptions to the without prejudice principle must apply. Now, the good news about the without prejudice principle is that it applies to conversations in respect of any type of subsequent claims. It could be unfair dismissal, breach of contract, or discrimination. And provided the without prejudice principle applies to the negotiations, they can't be referred to in any such subsequent claim. However, and as I said, there are three preconditions in order for the without prejudice principle to apply. And it's important to understand this because I think sometimes people do think that you can just say something is without prejudice and then head off and say whatever you want. So the first precondition is that there must be an existing dispute between the employer and the employee. Whether or not there's an existing dispute will basically depend upon whether an employee has either bought a claim or might reasonably contemplate doing so. And it can be quite difficult to determine what constitutes an existing dispute. For example, the fact that an employee has raised a grievance will not necessarily constitute an existing dispute. there is a practical point here, because what you can't do is to raise an issue with an employee for the first time out of the blue, where the employee was previously unaware of an issue, and then seek to rely upon the without prejudice principle, because there won't actually be an existing dispute at that time. The second precondition is that the discussions, the confidential discussions, must represent a genuine attempt to settle the dispute. Merely setting out the party's respective position or criticizing the other party won't count. Thirdly, there are some limited exceptions whereby conversations that you might have regarded as being without prejudice can actually be referred to in subsequent litigation. The first is where there is actually a dispute as to whether a settlement agreement has in fact been concluded, and if so, what its terms are. Now, a caveat here, obviously it's important when you're having without prejudice negotiations to ensure that all negotiations are marked as subject to contract, so that you don't inadvertently enter into a deal before you intend to do so. Secondly, whilst the courts recognise the merit of enabling employers and employees to have confidential discussions, the courts do not allow the confidentiality provision to mask any sort of unlawful behaviour. And therefore, without prejudice discussions can be relied upon in subsequent proceedings as evidence of misrepresentation, fraud, undue influence, blackmail, or unambiguous impropriety. And that's basically a posh word that means discrimination, intimidation, something that's clearly unlawful. And then finally, you can rely on earlier without prejudice negotiations if you've made what's called a call-to-bank offer. Now, this is where one party to a potential dispute makes an offer of settlement to the other and says that that offer of settlement is without prejudice, save us to costs. The point being that if the other party doesn't accept the offer, brings a claim, but then is unsuccessful in achieving more compensation than had been offered previously, the party that made the offer will want to refer to the earlier without prejudice offer if it is seeking costs on the basis that actually what it offered was more than the claimant secured. There is one significant practical limitation on the without prejudice principle, and that is the fact that there needs to be an existing dispute in order for it to apply, because employers will usually prefer to have an exploratory discussion about settlement options before a dispute has arisen. But of course, the risk in initiating such conversations is that if there isn't an existing dispute, they won't actually be confidential. Now, it was for this reason that in July 2013, the government introduced a supplementary statutory provision under Section 111A of the Employment Rights Act. And what Section 111A says is as follows. Any discussions or offers between an employer and an employee in seeking to agree terms regarding the termination of employment are inadmissible in a subsequent ordinary unfair dismissal claim unless there has been improper behaviour. Now, on the plus side, there is no need for there to be an existing dispute for this provision to apply. So you can see how it supplements the without prejudice rule, because you don't actually need that dispute. And recent case law has confirmed that the confidential protection covers the very fact that discussions have taken place, as well as their details. However, the statutory provisions do have a number of limitations. The first is that the discussions must be regarding the termination of employment. The without prejudice principle applies to the resolution of any dispute in the workplace, whereas the statutory pre-termination negotiations must be with regard to the termination of employment. Secondly, the statutory provisions will only apply in ordinary unfair dismissal claims. So if you have a claim for automatic unfair dismissal or breach of contract or discrimination, or indeed a multiple claim, the statutory provisions will not mean that any earlier negotiations are confidential and cannot be disclosed. Now, as we'll see in a minute, you might be able to rely on a combination of the without prejudice principle and the statutory principle, but this is quite a limitation. And then thirdly, the statutory provisions won't apply if there has been improper behaviour by either party. And to an extent, this mirrors the restriction with regard to the without prejudice principle. Now, the ACAS Code of Practice and Guide provides a non-exhaustive list of examples of improper behaviour, and they would include, unsurprisingly, all forms of harassment, bullying or intimidation or discrimination, physical assault or other criminal behaviour, victimisation, or indeed putting undue pressure on a party to settle a matter. Now, there are some specifics here. So, for example, the ACAS Guide suggests that if you make a settlement offer to somebody, as a minimum, they should be allowed 10 days to consider the terms of that settlement, and that to seek their response any sooner than that might amount to undue pressure. Likewise, it would be undue pressure if there was a threat of dismissal if the offer was rejected. But on the flip side, an employee is also barred from improper behaviour. So if an employee threatened to undermine an organisation's reputation if it didn't sign up to a settlement agreement, the employer could rely upon the earlier negotiations on the basis that there was improper conduct on the part of the employee. The ACAS Code and Guide also set out examples of what would usually not amount to improper behaviour, and there's some reassurance here. So, for example, setting out in a neutral manner the reasons leading to the proposed settlement agreement would not constitute improper behaviour. Factually stating alternatives if settlement could not be achieved, e.g. the possibility of commencing performance management proceedings which might lead to dismissal, would not constitute improper behaviour, provided the employer did not suggest that the outcome of the formal process would be predetermined. It also wouldn't be improper behaviour not to agree a reference as part of a settlement, or indeed not to pay for the employee to seek independent advice. Likewise, encouraging an employee to reconsider a first refusal of a settlement proposal would not be improper behaviour, provided it was done in a measured way. And as before, the pre-termination statutory provisions won't apply to a call-to-bank offer where you make an offer of settlement without prejudice, save as to costs. And as I said, there is an interaction between these two rules, because in ordinary unfair dismissal cases, where there is an existing dispute between the parties, settlement discussions and offers may be inadmissible under both the without prejudice and statutory provisions. In legal proceedings involving other types of claim, the statutory provisions won't apply because they only apply to ordinary unfair dismissal claims, but the without prejudice rule would still apply, providing there was an existing dispute and none of the other restrictions applied. It is also briefly worth mentioning that if you are an organisation in the public sector, then there are some other restrictions on the extent to which you can seek to settle disputes within the workplace or with regard to the termination of employment. The first restrictions came in February 2015, and the Cabinet Office set out guidance on settlement agreements, special severance payments, and confidentiality clauses on termination of employment. So, for example, and this would apply to civil servants and also to those working for arm's length bodies such as NHS England. And so the Cabinet guidance states, for example, that a settlement agreement in the public sector should not be used in order to avoid taking appropriate management action with regard to performance or discipline, should not be used to cover up individual or organisational failure, should not be used to prevent an employee speaking out, and should not be used to cover up the dismissal of an employee who has made a protected disclosure under the whistleblowing legislation. With regard to severance payments, they must be in the public interest and must provide value for money. And if it's an excessive payment, an unusual payment, you would need to seek legal advice in order for the payment to be made. And also, where a confidentiality clause is proposed, the employee must expressly be reminded of their rights under the whistleblowing legislation. Going forward, towards the end of this year and into next year, there will be further restrictions regarding public sector exit payments. The proposal will be that the total value of any exit payment should be capped at £95,000, and furthermore, as from next year, where somebody receives an exit payment on leaving a public sector organisation and rejoins another public sector organisation within 12 months, there may be the clawback of the exit payment that was made. So as I said, there are obviously a number of legal restrictions on what you can and can't do by way of off-the-record conversations. And what I want to do now is look at the practicalities of running such negotiations. And I'm going to start by looking at some do's and don'ts with regard to without prejudice negotiations. The first is, don't use without prejudice conversations or pre-termination negotiations to avoid properly tackling issues such as alleged discrimination. To give you an example, a lady returns from maternity leave and she complains to her manager that she is being ostracized by her team, who feel that she's not pulling her weight. Her line manager asks her to attend a meeting and tells her that this is a without prejudice meeting, which is independent of the normal grievance procedure. During the meeting, the line manager offers her a settlement package as a way of exiting the business. Now, aside from this being a questionable moral approach, if the lady doesn't want to leave and rejects the settlement offer and decides to bring a discrimination claim, e.g. for maternity-related detriment, and or resign and claim constructive automatically unfair dismissal, then the manager's conversation is likely to be admissible in any subsequent claim. The without prejudice protection won't apply because there has been unambiguous impropriety, it's a discriminatory behaviour, and also, of course, there isn't actually an existing dispute at the time that the settlement offer was made. The statutory protection won't apply because the claim involves more than ordinary unfair dismissal, and the manager's actions would undoubtedly be regarded as improper behaviour. Secondly, don't use without prejudice conversations as an alternative to invoking the relevant employer procedure, at least initially. So let's take the example where a new manager arrives and is quickly concerned about one of their team's performance. The issue hasn't been raised before by the old manager under the company's performance management policy, and the new manager decides that instead of invoking the formal process, he's going to try and shortcut by having a without prejudice conversation in which he offers an exit package as, quotes, things aren't working out. Now, by offering a settlement agreement, there's a risk of the manager being seen to be effectively saying, we've already made up our mind that you're leaving. Should the employee reject the offer and bring a constructive dismissal claim, then the conversation is likely to be admissible. The without prejudice principle won't apply because there's no existing dispute. The statutory provision won't apply because if the manager was found to have adopted a settle or be sacked approach, then this would amount to improper behaviour. In such circumstances, in order to enjoy the statutory protection, any offer of settlement should be made after you have invoked the formal performance management process and taking great care to ensure that it is clear that nothing is prejudged as regards the outcome of the formal process if the employee elects to reject the offer. Thirdly, don't use without prejudice conversations or pre-termination negotiations as a means of concealing unacceptable management behaviour. So, for example, a line manager holds a without prejudice discussion with a disabled employee, during which the manager says, I know I'm supposed to make reasonable adjustments for you, but we both know that ultimately your condition means that you have no long-term future with the company. So why don't we therefore agree some sort of sensible exit package now and avoid the inevitable? If the employee rejected the offer, then such a conversation would be admissible in any subsequent claim. The without prejudice principle wouldn't apply because there is no dispute and it would be regarded as unambiguous impropriety, improper behaviour. The statutory protection wouldn't apply, again because of discrimination amounting to improper behaviour. And again, of course, you're likely to have a discrimination claim, and so the restriction to ordinary unfair dismissal claims will mean that you can't rely upon the statutory provisions. So, having told you all the things you can't do, how do you actually go about having these without prejudice conversations? Well, some practical points first. Make sure you label all written and verbal communications as without prejudice. Even if you're relying upon the statutory provisions, mark everything without prejudice. Also mark them subject to contract so that you don't inadvertently enter into an exit deal before you mean to do so. It also makes sense to seek written agreement from the employee that they are happy to enter into such off-the-record negotiations. In terms of timing, the ideal situation is that any negotiation should begin only after an issue has been raised openly via a formal process, such as performance management or discipline. The ideal scenario is that the formal process runs in parallel with the without prejudice statutory conversations. And it's important, first of all, that will mean that there is the potential for there being an existing dispute, which of course gives you the without prejudice protection. Secondly, in terms of tactics, should the without prejudice off-the-record conversations break down or take too long, you can maintain in parallel the open formal process, therefore ensuring that there is no undue delay. If there is an existing dispute, you must of course avoid the impression that you prejudged anything, and when there is no live dispute, the advantage of starting with the formal process is that you're not going to have something coming as a bolt from the blue, which may remove the protection that you otherwise have. It's also important to avoid discriminating when conducting such negotiations. Now that might be because of the subject matter of the negotiations, and I mentioned a while back the lady returning from maternity leave or the disabled employee. It might also be that you have to make adjustments to the negotiations themselves. So for example, whilst the ACAS Code of Practice suggests that it would be reasonable to allow 10 days for someone to consider a settlement proposal, with a disabled individual with learning difficulties, it might be reasonable to allow longer. For someone who doesn't have English as a first language, it might be reasonable to give them longer. And actually, if you're dealing with someone who, because of their religion, has certain restrictions on the times of the week or the time of the year that they could have such negotiations, again, you would have to give some allowance for this. Now to finish with, what I want to do is just look at the chronological sequence of events if you were wanting to undertake negotiations on a without prejudice basis, first where there is an existing dispute, and secondly where there is no existing dispute. So let's start where there is an existing dispute. So here a problem arises for the employee, say it's poor performance. The line manager should commence the initial stage of the relevant formal procedure, inviting the employee to a meeting. At the conclusion of that initial meeting, the manager should explain how the formal procedure will be progressed in the normal way. Secondly, the manager can then explain, without prejudice, the option of alternative resolution via some form of settlement and ask if the employee is interested in this. If the employee is not interested in pursuing without prejudice discussions, then the manager should progress the formal process straight away, and again making the point that nothing has been prejudged. If the employee is interested in a settlement option, then the manager should seek written confirmation from them that they consent to entering into without prejudice negotiations, and the formal process should be put on hold for a clearly defined but short period whilst the negotiations take place on a without prejudice and subject to contract basis. And it's important to make the point, don't put the formal process on hold for too long, because in terms of your open correspondence, if the matter wasn't resolved and ended up in a tribunal, there may be some inexplicable gap between the initial meeting and you actually then pursuing the formal process thereafter. Following your without prejudice subject to contract negotiations, the manager proposes a settlement offer, again on a without prejudice basis, and the employee will need to obtain independent legal advice on it. If the settlement is accepted, that's the end of the matter. If it's not accepted, then the manager should recommence the parallel formal procedure. And then what if there is no existing dispute? And this is where, of course, you're going to have to demonstrate a degree of tact and diplomacy, because this may be coming out of the blue to the individual. So the manager invites the employee to a meeting, explaining that they may be accompanied by a colleague or trade union official. The manager tactfully introduces the problem that's prompted the meeting, say, for example, poor performance, and explains the formal procedure that will be adopted. The manager then explains that the business is fully committed to resolving the problem via the formal process, but that it's appreciated that some employees do not always want to go through such a process. The manager explains that if the employee is unsure about wanting to go through a formal process, then the manager would be willing to consider entering into a without prejudice discussion, explaining what this means about some form of a settlement, and should ask for the employee's view. And essentially what you're trying to do here is put into the mind of the employee that it's almost their idea. If the employee is not interested in a settlement, then the manager should back off and progress the formal process. If the employee is interested in a settlement and termination of employment, then the management should again seek written confirmation from the employee that they consent to entering into negotiations. The formal procedure should be put on hold again for a clearly defined short period whilst negotiations proceed. If following negotiations the settlement offer is accepted, then that will be the end of the matter. If it is not accepted, then the manager should initiate the formal procedure. Okay, well that concludes the end of the webinar. And what I'm going to do is to deal with as many questions as I can in the next few minutes. And as I said, if I can't deal with all of the questions that have been submitted, then I will respond to individuals afterwards. And as I also said, the slides will be sent out to everybody today after this recording. I've also set out here my contact details, which you will get on the last slide today, should anyone want to get in touch or check out our website, etc., and social media. So I'm going to have a look and see whether or not actually anybody's raised any questions. Right, well, I've got one that's come through. This is an interesting one. What if an employee raises a without prejudice discussion out of the blue? So they approach a manager and say that actually they're not happy, they don't think that they really fit in, and they would be interested in going. Well, of course, ultimately it's a commercial decision for management as to whether they are interested in entering into any form of settlement agreement, because the short answer would be to say to somebody, well, resign. However, it may be felt better that rather than having somebody stay when they're not happy and with the risk that they will become disruptive or unproductive, then it would be worth entering into some form of without prejudice negotiations. I think the important point is this. First, you need to seek the employee's written agreement to entering into those without prejudice negotiations. And you also have to explain to the employee what the practicalities of that means in terms of not being able to refer to them subsequently. I think you also have to be very clear with the employee that if in fact a mutually acceptable deal cannot be reached, then you're not going to be just giving them pay in lieu of notice or a lump sum to go away. Of course, it is difficult in practice if you have that sort of a conversation, the negotiations break down, and then you're left with somebody who's clearly unhappy, and you think you've got somebody who's not committed, and so on and so forth, because that clearly tends to have quite an adverse impact on the workforce. Another question that's come through is, what if you are in the process of defending an employment tribunal claim and the claimant puts in without prejudice correspondence, or indeed, I suppose, during the course of a hearing seeks to raise without prejudice correspondence? Well, in a sense, if what they're seeking to introduce is without prejudice correspondence into a tribunal bundle ahead of a hearing, then it's easy enough. One can reject that and say, well, it's without prejudice. And it may be that what you need to do is to, perhaps at a preliminary case management hearing, seek the tribunal's direction that such correspondence should not appear in the bundle. Obviously, the preference is not to seek confirmation from the actual tribunal that will hear the claim, because the very fact of making that application means that they're aware that there has been some without prejudice negotiations. If you are in the middle of a hearing and a claimant starts to seek to rely upon earlier without prejudice conversations or correspondence, then the important point is for your advocate to immediately interrupt the hearing and say actually that what is sought to be raised is confidential and is protected by one or both of the without prejudice principle or the statutory provisions. Tribunals are pretty experienced about this. For the most part, in fairness, particularly I think claimants acting in person, they don't always set out to be mischievous and raise something. The truth is that perhaps they themselves are a little unclear about what is open in terms of past correspondence and what is actually off the record or without prejudice. Okay, I haven't actually got any further questions from anybody, but if people do have any questions, do please submit them, and I'll be, I've just been told that more are coming. That's typical. But what I will do, because I'm conscious of the time, is I will instead endeavour to get back to individuals today if they have raised questions, because I'm mindful that people are probably waiting to go and have their lunch. So thank you very much indeed to everyone who has telephoned in today. I hope that you found the webinar useful and informative. The slides will be sent to you afterwards, and have a good day.